Concealed carry considerations. So we've heard a lot about this in the news in Illinois, and the reason this affects our business is because one of the provisions that is difficult to deal with is who can opt out of allowing it. So you have a conflicting interest. One of them is the right to carry a concealed weapon, which Illinois has now had to be dragged kicking and screaming into permitting because it was determined that it really is a constitutional right under the Second Amendment. So you've got this constitutional right to keep and bear arms, and yet you have conflicting rights of various property owners, whether they be business establishment owners or whether they be owners of homes, for example, who have some rights to be able to say, but not on my property, you don't get to come here packing heat. So that's where you get the conflicting interest. And of course, if you allow every place that a normal person would go to prohibit it, then the right has been so limited that it's not any good anyway. Because then, of course, you've got all the considerations. If you were concealed carrying and you're going to go someplace onto a property where you can't concealed carry, you've got all the considerations of getting the weapon off your person, but storing it safely and securely someplace that's not a concealed carry. So you've got all those different issues. So the statute is such that if you're in a commercial business that's open to the public or any sort of a public venue, if those types of places want to prohibit, and there are certain places that are just off limits, period, like I believe schools, establishments that derive more than a certain percentage of the revenue from liquor, in other words, designed to target bars as prohibited venues, but not necessarily restaurants. So certain places are just statutorily off limits, period, for private citizen concealed carry. Then owners of property have the right to be able to say, we, the owner, aren't going to allow you to do concealed carry on these premises. And interestingly, as Steve Bohenik makes the point, it's technically under the statute limited to owners. So, we own this building. Commercial lessees technically don't have that right in the statute. It's going to ultimately be something that'll have to be settled in the courts or with a cleanup follow-up legislation. Because right now, a lot of commercial establishments, the proprietor is a lessee, and if a lessee doesn't technically have that right. So the best practice is if you have a business, whether you own it or rent it, your best bet if you want to prohibit it is you have to have public signage. And even though technically if you're a tenant business proprietor, you don't technically have the right, you're still advised under this article that Steve Bohenik has written, go ahead and post the signage anyway, and if somebody actually contests your authority to do that, well, that's going to be an argument for another day. But most people walking in the door of a public establishment don't know off the top of their heads if you own it or not. So in the case of businesses and public type places, you need to have a sign. In the case of private property, you don't have to have a sign. So how does this most likely affect us? Well, in the realm of showings, on both ends of the showing process. From the seller side, you may have sellers where if you ask them, and you may want to start asking them because they may not think of it, but they may have a strong opinion if they know it could happen. They may have a strong opinion that they do not want to allow concealed weapons carried onto their property. Now, they wouldn't have to have a sign posted publicly that says that, but as a practical matter, you would probably want to put that, as I said, into the same category of please remove your shoes. I mean, make it obvious, remove your shoes and guns. Please deposit your gun in your shoe and leave it here where the cat can play with it. So as a practical matter, you do want to be aware that the more obvious the sign when your house is on the market and you're getting strangers coming into your house. If you want to prohibit concealed carry, signage probably is the most practical way to go. It isn't required, so a private property owner could prohibit it without putting up a sign, which means that we, in our industry, need to be prepared to watch for an agent remarks notation or something in the showing instructions. I suspect it will be very rare that we're going to encounter a listing that says, please don't bring your guns into this house. Most people aren't going to think about it. Now, the flip side of that is you have to decide and at least be mindful of the fact that you may now start having clients carrying concealed weapons when they're in your car driving around doing showings. So just something to be aware of. I don't know for certain if you would have an absolute right. Of course, the easiest way is make them follow you in their own car if you want them not to be carrying weapons and they don't want to comply with your request. But just be aware of it. I mean, it raises, when you start to think it through, it raises a pretty complex set of issues. Even if most of the time sellers aren't going to think about it, many sellers aren't going to care. And you may not care if your buyer clients are packing heat or not. But you're going to occasionally have people who do have a strong opinion, and you have to have at least a cursory sense of what their rights are to prohibit it on their property, so that you're able to tell your clients, if you're on the buyer side, you're probably going to want to leave the armory at home. Any questions on that?
Yeah. What are the rules with regarding concealed carry? You can have it on your person, in your pocket, in a holster, in a purse?
I haven't even read the detailed rules, and some of the rules are still being promulgated. So the statute took effect already, but the actual ability to issue the licenses is delayed until next month to provide enough time to put into place some of the administrative rules framework, and for the state police to be able to determine how they wanted to be, state police and sheriffs, actually, I believe it is, to be able to do screenings at the local level. So it's not, yeah, exactly. So it's not really shocking that in the case of the state of Illinois, they're probably going to manage to bungle some aspects of this new legislative and constitutional right. So just be aware of it, and when you hear news coverage of it, be mindful of how it affects you when you are driving buyers around, how it affects you when you have listings and listing clients who have a preference, and also, as Mary Ann had alluded to, open houses. But it also means, the flip side of that is, as long as you're hosting an open house and you are not on premises where the seller has prohibited concealed carry, there's the issue of now agents who were very vulnerable, especially in open house situations. If there was only one visitor and one agent there in an isolated environment, concealed carry offers some opportunities for some more potent self-defense than people have had before. So just be aware of the issue in general, and always be thinking critically as you're hearing new news developments on it in the state of Illinois, how it impacts both you individually and whether you have an interest in concealed carry yourself, but also how it impacts your clients and your dealings with your clients.